John Crotts. I'm an estate planning attorney with Keaton Law. I wanted to talk to you today about probate or estate administration. Probate is a nasty word that gets thrown around from time to time, and it doesn't have to be, but it is something that you want to be careful about once you get involved in having to manage an estate for someone. So what is probate? Probate is simply the process that your loved ones go through upon your death to handle your estate. And that is something that has to occur through the courts in most cases. So if you had a will, then the will is taken by the named executor to the court to be probated and an estate opened. If you didn't have a will, then your next of kin or your family will work with one another to determine who is going to be the point person or the administrator of your estate, and that person will go to the court to apply to become the official administrator and get that estate opened. But there's a lot of critical steps involved in probate, which is why having an attorney involved is preferred. But people do try to do this on their own. Some have success. Others end up getting in way over their heads and have to hire an attorney later. We get hired both ways, but we certainly do recommend that you have an attorney at the outset because it is a very tedious and time-consuming process. In North Carolina, on average, a full estate can take in the neighborhood of a year or in maybe 14 to 16 months in some cases. Just depends on the size of the estate and all of the different factors involved. In some cases, we're able to get those closed out in less than a year, depending on what all we're dealing with. The process starts, as I mentioned earlier, by the executor or administrator, if there isn't a will, filling out an application, asking the court to give them letters of appointment, making them the official executor or administrator of the estate. That is the golden ticket for that person to go to the bank or anywhere else they need to go to get financial information, other records, allows them to communicate with any third parties as the official estate representative. Until that happens, there's very little that one can do to handle any of the affairs of a deceased individual. Even if you had power of attorney, a power of attorney ends at death and would not give you the ability to do anything on behalf of the deceased. So once the court formally appoints the executor or the administrator, or what we call a personal representative of the estate, that individual has to do an inventory of all of the assets of the deceased and has a limited time to do that. In North Carolina, that's typically 90 days, although we do have to give a preliminary inventory at the time of the initial application. We have to run a notice to creditors in the newspaper that gives creditors a limited period of time, around 90 days, to file any claims against the estate. And then after that time expires, we can begin the process of trying to work through the final accounting of the estate. The executor or administrator has to give a detailed accounting to the court of all money that comes into the estate and all money that goes out. And the court has to approve all of those expenses. When the estate is initially opened, if there's going to be any funds, any money that the deceased owned, then the personal representative of the estate is going to need to open an estate bank account and get a federal tax identification number for that account. We always encourage our clients to schedule a meeting with a tax preparer or a CPA to discuss any tax obligations that the decedent had and to oversee any tax obligations of the estate during the time the estate is opened. We also recommend that you contact the Social Security Administration as quickly as possible to let them know that the decedent passed away, to have the Social Security deposits stop so that doesn't later get clawed back by the Social Security Administration. We certainly do recommend that you have an attorney assist you with this process because it is so tedious in nature. We have seen individuals get themselves into a lot of trouble. As an executor or an administrator, that you are a fiduciary, and as such, you are bound by the law to do certain things and not do certain things. So having an attorney advise you through that process could keep you out of trouble, including contempt of court. So it's not something to play around with. You want to make sure that you've got sound legal advice as you go through the process. If we can assist you with an estate or probate matter, give us a call. We'd be delighted to have a conversation with you and try to help you work through that.